This is, we're going to be discussing today the COVID-19 effect on Ohio's workers' comp. Right now, you know, we're all having a number of problems with COVID-19 in the state of Ohio. And we're going to talk today about how that's affecting workers' compensation claims. As a general rule, exposure to viruses are not compensable under Ohio's workers' compensation law. Most claimants, however, are going to have a difficult time establishing a compensable workers' compensation claim unless they can prove that the virus contracted in the course of and arising out of employment. The elements of a workers' compensation claim in Ohio, claimants got to prove three elements to have a compensable claim for an occupational disease, which is what the COVID-19, the coronavirus, would be. Claimants will have to prove that the disease was contracted in the course of and arising out of their employment, that the disease is peculiar to the claimant's employment by its causes and the characteristics of its manifestation, and the conditions of the employment result in a hazard which distinguishes the employment in character from employment generally, and the employment creates a risk of contracting the disease in a greater degree and a different manner than the public generally. So as you can see, that's a pretty hard standard to overcome, and it's going to be a pretty big burden on claimants to prove these claims. The claimant must establish that they contracted the coronavirus as a result of an exposure in the workplace. That means the claimant must submit a medical opinion from a doctor who's diagnosed the coronavirus and causally relates that condition to an exposure at work. And it's going to be very difficult for claimants to obtain this type of a medical opinion in a pandemic context with the coronavirus existing throughout the general public. How is the claimant going to prove he got it at work versus he got it in the grocery store, he got it at church, anywhere else? Now, certain occupations may make it more likely than members of the general public to be infected, such as healthcare workers, first responders, etc. But unless you have a position in one of those occupations, it's going to be virtually impossible to prove what was the causation and where was the disease contracted. With the coronavirus, it's going to be difficult to determine exactly where the claimant contracted the virus. So how is a claimant going to be able to hold an employee responsible for a compensable workers' compensation claim? They would almost, you know, in the perfect situation, they would have to know someone is tested positive, they came into contact with that person in the workplace. But even then, who's to say that they didn't contact someone outside the workplace who was also positive? So exposure is going to be very difficult. Employers are going to be able to make the argument that exposure could have happened anytime, anywhere outside of employment, and that's going to be a very good argument. You combine that with the fact that there's a latency period for this virus of between 2 and 14 days, it's going to make pinpointing the exposure which caused it virtually impossible. And even in a liberal system like Ohio's workers' compensation system, it's going to be difficult for a claimant to be able to prove that they were exposed in the workplace and that exposure is what caused it. Now, it's likely claimants' attorneys will be filing these claims anyway. That's the way they do it. They're going to look for people to get money from some source. As an employer, you should treat these claims as any other type of flu, virus, or illness. Don't treat it any differently. And as a general rule, I would think as an employer, you should contest any claim that's filed against you for the coronavirus. Take that issue to hearing, make the claimant have evidence that he has the coronavirus and proof of exposure, and he has to prove that that exposure happened in the workplace. I want to talk now about intentional torts for a second. Under Ohio Revised Code Section 2745.01, employers may be liable for intentional torts. And what I'm putting on the screen now is the actual law itself. It states that an action brought against an employer by an employee or by the dependent survivors of a deceased employee for damages resulting from an intentional tort committed by the employer during the course of employment, the employer shall not be liable unless the plaintiff proves the employer committed the tortious act with the intent to injure another or with the belief that injury was substantially certain to occur. That's two things. You have to prove intent or belief that the injury is substantially certain to occur. And the statute provides a substantially certain means an employer acts with deliberate intent to cause an employee to suffer an injury, a disease, a condition, or death. Now, there's a couple of rebuttable presumptions under the statute, and that's misrepresentation of a toxic or hazardous substance or the deliberate removal by the employer of an equipment safety guard. For purposes of the coronavirus, the safety guard is irrelevant. My only concern is a claimant's attorney trying to argue that the coronavirus was some type of toxic or hazardous substance. That's not the intent of the statute, but I can easily see a claimant's attorney trying to make that argument. In Ohio, the intentional tort law allows claimants to file personal injury lawsuits against the employer under this theory of intentional tort. And again, they have to basically show that the employer knew or was substantially certain that an injury would result from the employer's action. These lawsuits are heard by a jury to determine whether the employer had actual knowledge or was substantially certain that an injury or disease would occur. And again, there must be evidence of an actual deliberate intent to injure the claimant. And those are going to be very high standards to meet. Like I said, there is the rebuttable presumption under the statute that talks about the deliberate misrepresentation of a toxic or hazardous substance. The statute itself never contemplated this, but I can see some aggressive claimants attorneys trying to make this argument. If they do, you're going to have to fight it. It's all you can do. The intentional tort action is going to allow the claimant to file the independent tort action and to seek damages in addition to the workers' compensation claim. So keep in mind that in addition to the workers' compensation claim. And the question is ultimately going to be whether an employer's actions or inactions in connection with the coronavirus rises to the level of deliberate intent or substantial certainty. For example, did the employer take all the actions that the government was recommending to make sure that people were not exposed to the coronavirus? I am sure the claimants are going to argue they did not. And then that's going to be a jury issue. Again, the question ultimately is going to be whether, as an employer, your action and more likely your inaction in connection with the coronavirus rises to the level of deliberate intent or substantial certainty. Again, claimants are going to try to make this argument that it's a misrepresentation of a toxic or hazardous substance, but I don't think that'll be a winning argument. The safe course is to make sure you follow all recommendations from the federal government, the state of Ohio, and county health departments. If you as an employer, you're doing that, I think you'll be in a good position. So these are very uncertain times. Again, as an employer, make sure you're following all of the recommendations being put out by the federal government, the state of Ohio, and your local health departments. If you have any questions, please feel free to give me a call.
We do have one question. That is this only related to Ohio?
The presentation today relates only to Ohio, but the coronavirus obviously is worldwide and certainly nationwide. This presentation was dealing with Ohio's workers' compensation system. Other states are going to be similar, but I can't sit here and tell you for certain how other states are going to react under the workers' compensation system.
All right. Thank you for attending.